Hello students, welcome to the daily news analysis at Narayana IAS Academy. Today we are going to deal with four most important articles from The Hindu and Indian Express, and we are going to cover these articles in detail in comprehensive manner because these are the articles which are highly relevant for the upcoming examination, whether it is prelims or the mains. Now before we start with our session, I have a quote for you. A quote by Norman Vincent Peale. He says, when you change your thoughts, remember to also change your world. And when he says change your world, he's talking about your actions. So people will say, change your mindset, change your thoughts, and everything will change. Just by changing thoughts, things are not going to change. You have to make changes in your actions, in your behavior too. Right? So good quote for all of us. Now, moving ahead with the four articles of the day. The first article is from Indian Express, page number 14. Why Supreme Court struck down center's orders on retrospective green clearance. So this is about environmental protection, right? The second article over here, this is from The Hindu, page number 10. Report reveals delayed wages are a key factor to mismatch between MGNREGA coverage and delivery. So MGNREGA is in news since a long time. Since last 6 months, I'm continuously observing that this scheme is in news. And it's a very important scheme. So we'll study this part. Then third news from The Hindu. Amit Shah launches E0 FIR initiative. You should know what is this initiative specifically talking about. It's about the FIR, but what does it exactly mean by E0 initiative? And the last article over here from The Hindu, page number 6, getting the micro picture at Panchayat level. So there is an index related to Panchayats. We'll study that index in detail. Okay. So these are the four articles. The first one is quite relevant for your mains examination. Although in prelims also there could be questions from all these articles. Now, look at the first article of the day. Why Supreme Court struck down center's orders. Now, which orders are these? These orders are related to environmental impact assessment. Okay, so you should know what is this exactly. This is important for your GS paper 3, conservation, environmental pollution and EIA. Now, look at this previous year question asked in the year 2013. There is a direct question on environmental impact assessment, EIA. So if you read this question, you will get an idea about the kind of questions UPSC is interested in asking, and this theme is highly important for the examination, right? So moving ahead, let's understand what is exactly happening. Just give me 1 second. There is some technical glitch over here. Just 1 second. So yes, it's done. Now see the first article. If we look at the context of this article, what has recently happened? So recently, Supreme Court of India has made a significant ruling related to environmental protection. Now what they have exactly done? So earlier, Government of India, specifically the Ministry of Environment, Forest and Climate Change, they had brought some notifications. There was a notification brought in the year 2017. Then in 2021, they brought office memorandum. And these two things have been cancelled out by Supreme Court right now. Okay, so these two notifications, they were from the ministry directly. And when it is being cancelled, so it becomes an important news for all of us. Now, when we talk about these notifications or these government orders, these were brought by government wherein government tried to allow industries to start work on projects without first getting any environmental clearance. So government is actually thinking about developmental projects. Government wants the businesses to grow. So what they said, you don't need to get the environmental clearance first. You can get it later on. You can later on apply for any such approval. So if I have to say, in legal terms, we can use this term called ex post facto clearance, which means giving permission after the act has already been done. Once you're done with it, then you ask for any such permission. So this is very important. Ex post facto, or simply we use this term retrospective clearance. Okay. Now what Supreme Court has said. Supreme Court ruled that this kind of a practice wherein you are saying you have to go for this ex post facto or retrospective clearance, this practice is highly unconstitutional. This is not acceptable. It completely violates the environmental laws and it goes against the Indian Constitution. If you see Indian Constitution, article number 21. So such a clearance mechanism goes against article 21. It guarantees, this act, this article guarantees a right to life and personal liberty. And when we talk about right to life, it includes right to environment, clean environment. Okay. So if you see the interpretation by Supreme Court regarding article 21, they have very clearly mentioned that health and environment are part of this article. That's why they have said these notifications by the ministry, they are unconstitutional. So they have been cancelled now. When you allow industries to operate without any proper check, this is going to harm the health, this is going to harm the well-being, and that's not acceptable. Okay. Now, if we want to understand why this ruling exactly matters, so we need to understand this concept of environmental impact assessment. So you should know this concept very specifically. Environmental impact assessment. Now, if you go and ask United Nations, so we have got this United Nations Environment Program. According to them, environmental impact assessment, it is a kind of tool, a tool that can be used to predict how a project, let's say we are building a new project, we are going for a new industry or something, how this proposed project is going to affect environment, is going to affect society, is going to affect economy. So before the project actually starts, we start predicting, and to predict, we come up with environmental impact assessment. So let's say, for example, if there's a company who want to build a dam, just for the sake of example I'm saying. So what this EIA or environmental impact assessment will do, it is going to examine how it impacts the rivers, how it impacts forests, how it impacts nearby communities, the local wildlife, etc., etc. So the main goal over here is to help the decision makers to think very carefully about these environmental consequences that this project is going to bring before you give the approval to this project, right? And this EIA is very important because it actually brings multiple benefits for us. For example, if I have to give some examples, first of all, the decision making part, it will be an informed decision making. You have the right information with you. Authorities can understand the risks that are associated with the project and the benefits associated with the project before you give the approval or the green signal to that project, right? This is one part. Second thing, it is going to help you in early detection of any kinds of problems. Let's say pollution, let's say loss of biodiversity. So all this you can know in earlier. So this means it can be addressed before these issues start causing any big damage because of these projects, right? Then thirdly, it also involves public giving this local communities, because what we are doing is we are giving voice to the public, we are giving voice to the local communities. Here there is role of public in the decision making, because this decision of bringing any business or any industry in an area, it is going to affect the land and livelihood or the resources of these local people or local community. So we are bringing them also. And last thing, such EIA, environment impact assessment, is going to support sustainable development. So when we say sustainable development, we say that we are going to meet the needs of present time without damaging the environment, because the environment is needed for our future generations, right? So this is the core idea that we can understand about environmental impact assessment. Now, as far as this idea is concerned, in India, this idea of environmental impact assessment, it started gaining attention in 1970s and 1980s. That was the time period when policy makers started looking at this concept. So at this time, some big projects like, let's say, dam project, road building, factories, all these were built, but their harmful effects on the people and on nature, that was becoming very much visible. And that's the reason people started talking about it. And to fix this kind of a damage, this kind of a problem that we were getting, Government of India made it legally necessary to get some kind of environmental clearance. You have to first get this clearance. Now, such a rule, such a formal rule came in India with this act called Environmental Protection Act in 1986. This act is very important for us. So, Environmental Protection Act 1986. After this particular act, there was a notification also brought. So the notification is EIA notification, which was brought in the year 1994. Okay. Now when you look at this act, when you look at this notification, overall the rule says that there are some kinds of projects, certain types of projects which must get government approval. And only after government approval, means you will get the government approval only after an EIA is done, environmental impact assessment is done. That assessment will reach to the government, then government will give approval. This was clearly mentioned. Okay, this was the story till this time. Now something interesting happened in the year 2006. Now there was one more notification brought by government, environment impact assessment notification in the year 2006. And this notification actually continued the same thing. It actually improved the same process. It said that no industrial or no infrastructural project can actually begin without any prior environmental clearance. So what we did here, that clearance must be obtained before you start constructing, before you start operating any project. And here they have actually given an entire process. If you read this 2006 notification, they have mentioned things in a step-by-step manner. So there's an entire process of EIA, environmental impact assessment, screening, scoping, public hearing, review and decision making, all this. Now when you look at this entire process, first thing is screening. In the screening, what you do is you decide whether a project even needs any environmental impact assessment or it doesn't require. So this will be done based on the size of the project or the impact it might have. So this is called screening part. The second part over here is scoping. Scoping means you are trying to identify what environmental issues should be studied in the report. So this is your scoping part. Third, public hearing. So public hearing means you're looking at local people, the local community. So these local people, they're allowed to share their views, their opinions or their concerns regarding any project. And then comes the last stage, review and decision making. So to review, we have got one expert committee. Expert committee is going to review the environmental impact assessment report, and then the committee will suggest what to be done. They are going to decide whether we are going to grant clearance to this project or not. This is how things will go. That's what that was something that was mentioned in the 2006 notification, right? Now when all of this is being done, who is regulating all this thing? So the central body who is overseeing all of this process is your Ministry of Environment, Forest and Climate Change. And now this is at the central level. At the state level, this is handled by environmental impact assessment authorities. In short, we call them as SEIAA, environmental impact assessment authorities. Okay. Now this is the story that we understand. Now what happened in March 2017? This Ministry of Environment, Forest and Climate Change, they issued a notification that actually broke this rule. We were following this rule, but the rule was changed by a new notification in 2017. Now this new rule, what it did, it actually allowed companies that had already started working without any clearance, and it said that even if you have started work, that's fine, you can apply for this kind of approval or this clearance afterwards. After starting your work also, you can go for it. Now this was clearly against the 2006 notification, right? This is something we need to remember about this 2017 notification. Now there was a 6-month window which was given for such industries to regularize their status, to apply to get the clearance, and all these things were being provided. Now here came the public criticism. Many critics actually strongly opposed this kind of rule, this kind of idea. They argued it would actually encourage people to go for violating the law. Violate now and ask for the permission later on. This is the attitude that you're setting as an example. So what will happen? Industries, they are going to break the law. They know that they could get away very easily later on. So they will break the law. And looking at all these things, Supreme Court came into picture. So recently, 2025 May, Supreme Court struck down this new rule which was brought by the ministry with the notification in 2017. The judges of the Supreme Court, they made it very clear that retrospective approval, that means giving the permission after the damage has been done, this is not at all acceptable. Retrospective approval is not acceptable at all. The judges, they even said that government was not actually protecting the environment but actually shielding those who broke the law. So the court asked whether economic development should come at the cost of environmental destruction. Now this is something very, very sensitive topic. And here the, what we say, Supreme Court is doing, they're giving substantial importance to environmental part. They firmly said that this is not acceptable, and this judgment, it clearly stated that when you give clearance after the harm is caused, this causes, or this goes against Article 21, goes against Article 14 also. See, you read Article 14, it says we are providing equality before the law. If one company is following the rules, another skips the rule, but then it can get the approval very easily later on. So this is not equality. So this goes against Article 14. And the court also called government's move as something called craftily drafted, which means simply that it was designed very cleverly to bypass this legal requirement. Now this is something we don't expect from government. You're using your clever mind to bypass the legal mechanism, so that means you don't respect the law, right? And that's the reason court actually rejected this idea that one time opportunity to apply for clearance makes this action legal. No, it's a wrong practice, and a wrong practice does not become right just because it happens once, right? And the court actually, it's not like court just said it whimsically. Court came up with different case studies of the cases. So the decision was supported with some past judgments. So there's a judgment in this case called Common Cause versus Union of India in 2017. You have this case Alembic Pharmaceuticals versus Rohit Prajapati 2020 case. We look at the first case. Here, court said that illegal mining without clearance is not allowed to be regularized. This was said in the first case, this one. And in the second case, court had clearly stated that ex post facto environmental clearance, they are not part of the law. They are not allowed. And these decisions show that environmental law is meant to prevent harm, not to just clean up after the damage has actually occurred. So when you read this case, it clearly actually raised the constitutional and ethical issues involved over here. When you look at right to life under Article 21, it's not just about surviving. It's about living in a safe and healthy environment. You look at Article 14, right to equality. It means lawbreakers should not be rewarded, and side by side we expect that the law abiding citizens, they are not ignored. So legally, when you allow such clearance, that actually breaks the rule of law, it violates the natural justice, which is the core principle which says fairness must guide all decisions. So this we need to understand. And when we look at things from ethical perspective, it actually damages public trust. People will not trust you. It tells people that rules can be bent for powerful interests. That's possible. It harms the idea of intergenerational equity. There is a belief that we owe whatever we have, we owe it to the future generations. That's why we need to protect the nature. So it goes against this also. So when I look at this judgment from Supreme Court, I say that the implications of this judgment are going to be very wide reaching. Firstly, it makes it very absolutely clear that prior clearance is not optional. It's mandatory. You have to take it. Then it stops the policies that try to cover up the illegal actions after they have occurred, right? It shows that the judiciary is watching and will step in whenever executive is crossing its limits. This is also shown in this case very clearly. And this case very clearly sends a very strong warning to the industries that harming the environment will not be tolerated by Supreme Court or the Constitution. So this ruling actually helps us preserve ecological balance and ensure that the future development, it is going to follow the law, rule of law, right? And finally, we can say it actually prevents government from issuing any similar kind of notification in future. They've done it earlier, but now they will not do it, right? So this is how we see this entire article. Clear? So this was all about this environmental clearance part. Done. Now we reach to this second article of the day. Report reveals delayed wages. Now this is related to MGNREGA. You should know what is this MGNREGA scheme. Important for your mains as well as prelims. I suggest please read this previous year question asked in the year 2011. You'll get a good idea about the kind of question UPSC has been asking. Okay, please take few seconds and read the question. Done? Now, so recently there was a report brought by Listec India. Now, if you look at this report, it has brought our attention to a very concerning trend in the implementation of a scheme called as MGNREGA scheme. The long form is Mahatma Gandhi National Rural Employment Guarantee Scheme. So if you read the report, it says that there are more rural households who have registered under the scheme in the financial year 2024 to 2025. But the actual number of work days provided has gone down. And this is a kind of mismatch between this coverage, the scheme's coverage, and the actual delivery of the employment that is being provided over here. So if I have to say the same thing in simple terms, I can say even though more people are actually signing up, are actually registering over here, very few people are actually getting the work. And one of the key reasons identified for this is the delay in wage payments. When the wage payments are made, the amount of money the people should get, that is being paid, there's a delay. And because of this delay, people feel discouraged. They don't seek this employment under the scheme because they feel discouraged that they're not getting payment on time. What's the use of it, right? So to understand this issue more clearly, let's first understand the scheme, particularly MGNREGA scheme. We should know the basic part. MGNREGA, Mahatma Gandhi National Rural Employment Guarantee Act 2005. So there was an act that was passed in the year 2005 by Parliament of India. So when you make an act, that means somewhere you're making a legal promise. So government has made a legal promise. Under this act, government said that we are going to provide at least 100 days 100 days of unskilled manual work in every financial year, and this will be provided to every rural household where they will find any adult member who just want to work. So simply, anyone who says that I'm unemployed, government is going to give you job, but this job will be provided only for 100 days, right, in a financial year. Now, when you read about this scheme, it is actually run by Ministry of Rural Development. So there are state governments who are partnering in this scheme, but the role of Ministry of Rural Development will be very high. And at the local level, we have got Gram Sabhas, Gram Panchayats. They also play an important role when it comes to planning for any kind of project, monitoring any kind of project, all these things. Now, over the years, what has happened? We have also made use of many technological tools. Many tools were introduced so that we can improve the transparency and efficiency in this MGNREGA scheme. For example, there is this app called NMMS app. Okay, that was introduced in the year 2023, and right now it's being used to mark the attendance of workers. So twice a day, using their mobile phones, they can do this attendance. There are some other tools also. For example, we make use of geotagging. So wherever the work is being located, that work site can be geotagged. Then we have this electronic fund management system, EFMS. We have got management information system like MIS portal, and we've got online job cards, wage payment systems, everything, right? Now, when we look at this MGNREGA scheme specifically, it has some core features that are very unique that we need to remember. First of all, it covers all the rural districts in India. This is about rural India, not the urban part. So it covers all rural districts in India, and it is open to any citizen whose age is above 18 years and who is actually willing to do some kind of work. But which work? Unskilled manual work. We're not giving any skilled work as such. It's an unskilled work. And here we're guaranteeing 100 days of work per year. Now, for those 100 days, you will be paid some wage, and the rate of this wage is actually based on the minimum wages set by each state. So, if you see in India, the minimum wage amount is different in different states. So, accordingly, this number will be provided here. Now, the important thing is the law says work must be given within 15 days of a person's demand. I demanded today, in 15 days, I should get the work. But in case government is not in a position to provide the work in 15 days, the government will have to pay the unemployment allowance. Some amount of money has to be paid, and this amount is actually 1/4 of the wage for the first month, right? And it is half the wage after that. So initially 1/4, later on half. This has to be provided by government. And the work must also be given close to workers' home. So let's say your home is situated here in the 5-kilometer vicinity. This work has to be provided, or else you have to give the travel allowance to this person, right? Now, when you look at the wages, these wages are actually supposed to be paid on weekly basis. At most weekly it is expected, but if not weekly, at least you should pay this amount in 15 days. And in case there are any kind of delays, the worker is entitled to some kind of compensation from the government. So for this, many social audits are done. So we have this something called social audit, which is done at the village level. These are very much mandatory under section 17 of this act, and because of this audit also we get transparency in the system, right? Then at least half of the projects must be planned and they must be executed by the Gram Panchayats. So remember the role of Gram Panchayats over here, right? Now, let's take India report. This is important for us. If we come back to this report for the year 2024-25, this report reveals some important statistics. So the number of registered households, they have got increased from 13 crore to 14 crore or 14.98 crore. But the total number of person days employment, people who are getting employment, that has dropped by 7%, 7.1%. So on average, a household received only 50 days of employment in 2024-25. Earlier it was actually 52, right now it is 50, so it has decreased. And this clearly shows that although more families are enrolled, very fewer days of work is actually being provided to these people. And the main reason, as I mentioned very clearly, there's a mismatch in the, or there's this delay in the wage payments. When workers don't get the payment on time, they lose trust in the system and they avoid applying for any kind of work. This is one major issue. Another issue is the stagnation of this scheme's budget. We don't see the budget increasing as such. And even though these enrollments have gone up, financial support from the government has not increased. Number of people registered have increased. The amount that was being provided, that has not increased. That's the reason why there is delay, we can understand. And this puts pressure on the entire system and results in fewer work days being made available to people who actually need them the most, right? So this is how we can understand what is exactly happening over here. It's a very serious concern for all of us. Now, next article about this E0 FIR, right? This is important for your GS paper 3, cyber security, money laundering prevention. Regarding all of this becomes important. Now I suggest you to read this previous year question so that you can get an idea about the kind of questions being asked. Please read. I'll give you a few seconds to read. Done? Good. Now what is happening? So recently, Ministry of Home Affairs, they have launched a new initiative called as E0 FIR. Now this E0 FIR is actually designed to deal with the rising problem of cyber financial frauds that are happening in India. Now these frauds are actually increasing in number, and if you see, often it involves large amount of money. So this initiative has been brought, and overall this initiative is part of India's crime cyber crime coordination center. We have this system called I4C, Indian Cyber Crime Coordination Center. So this initiative is part of this I4C, and it introduces a system where complaints of major financial fraud can automatically become some kind of FIR. So you get a complaint, it automatically becomes FIR, and this is very important. This is a major step in using the technology to improve the law enforcement, specifically in these cyber crime cases. Okay, so when we talk about this zero FIR initiative or E0 FIR initiative, this system is especially helpful for the public. What it does is it makes the process of filing the complaint much more easier. Let's say if someone becomes a victim of any kind of financial cyber fraud, which involve, let's say, amount which is more than 10 lakh rupees. So what they can do is they can report it through this National Cyber Crime Reporting Portal, NCRP. So we have this portal. Or there's a helpline also, 1930, they can call. Now once this complaint is submitted, it is automatically turned into an FIR. There's no need for any kind of for any kind of process wherein victim needs to go to police station as such. No, it automatically becomes FIR, and this actually saves time, saves effort, the stress during an already very difficult situation. All this will be saved. Now, when we look at any such project, actually this project started as a pilot project in Delhi. So there it was being tested to check how well it works, and if the system proves successful, government planned to roll it out across all states and all union territories. For now, high value complaints like those about 10 lakh rupees, they will be accepted for automatic FIR registration. And this limit of 10 lakh rupees that has been set to focus on the most serious and some impactful cases wherein government wants to focus first, right? And the system works through smooth integration of different technology platforms. It's going to connect the three major platforms that we have: I4C's NCRP, Delhi Police EFIR system, and NCRB's Crime and Criminal Tracking Network system, that is CCTNS. You must have heard about this, right? All these platforms, they're going to share the data in real time, and this makes this registration of FIRs very fast, very much accurate, right? Now, the use of this integrated technology, what it does is it ensures that there will not be any delay in case creation once, let's say your complaint has been filled, so there won't be any delay. And to provide the legal backing to this, it's not like you can do such things on your own. You need some legal backing. For that, we have this section 173(1) clause 2 of the Bharatiya Nagrik Suraksha Sanhita, right? These sections, these have been newly introduced. So when you read this law, it gives this automatic FIR process legal strength or the formal recognition that it requires. So FIRs created through this system are valid, they are enforceable just like any other FIR that you file in the police station. Okay. Now, an important feature of this process is the use of zero FIR mechanism. Now, this term, please focus on zero FIR term. Normally, a police station can only register a case if the crime has happened in their area, in their vicinity. But when we talk about zero FIR, any police station can register the complaint even if the crime has occurred in a different area elsewhere. They can still file, and that's called zero FIR. So what happens later on, the case is transferred to the correct cybercrime unit or the correct police station. So this is the basic approach when we talk about zero FIR, which is a good thing. And this approach actually ensures that action is not delayed because of these jurisdictional issues and all. This is useless for us, right? And this E0 FIR system that we have over here, it is part of broader work done by Indian Cybercrime Coordination Center. So this agency I4C, Indian Cybercrime Coordination Center, I4C. This is very important. This agency was started by Ministry of Home Affairs when in the year 2020. Now the aim of this agency was to create a centralized and coordinated response to the growing threat from cybercrime in India. Cybercrime is a very new domain for us. So here this I4C, it works with both the central government and the state agencies to make the fight against cybercrime more effective. Right. Now, one of the main services which is offered by this, which are offered by the I4C, is a National Cybercrime Reporting Portal. This portal is very important. This is an online platform wherein people can file complaints about the digital crime if they are victim of it. So it focuses especially on the financial frauds, online scams, cybercrime against women or children. And here citizens can report cases directly from home without visiting any police station as such. You sit at home and just do it. Then I4C also plays a key role in training the police, training judicial officers. It builds the capacity in handling cyber crimes through technical education, workshops, etc. It also runs the National Cyber Forensic Lab, which helps in collecting and analyzing digital evidence. And this lab is very valuable too. It helps in solving the cybercrime cases very much quickly, very much accurately, right? And when we talk about this E0FIR, this is one of the most recent effort by this I4C, we can say. Okay, so that's how we look at this particular issue or this particular topic. In a big picture, actually, our goal is to build a digitally safe India. Government wants people to use online services without any kind of fear. And by making the complaint process very simple, very fast, government actually aims to rebuild the trust that is there, trust in the police, trust in the legal systems. So citizens should feel confident, and the action will be taken very quickly, very fairly in case you come up with any problem. That's the assurance that we're getting through this E0FIR initiative. Clear? Very easy, we can say. Now, heading towards the last article of the day. Now, this fourth article is specifically related to local self-governance, or to be more specific, there's something called PAI index that we need to know. Okay, it's important for GS paper 2. Now, please read this previous year question to get an idea about the kind of questions UPSC has been asking. I'll give you 10 seconds, please read. Done? Okay. Now see, India has taken a major step towards improving village level planning with the launch of an index called Panchayat Advancement Index. In short, we will call it as PAI, Panchayat Advancement Index. Now, what is it all about? So, this is a new tool which has come into picture at a time when reliable data for local development has been very hard to find. See, the national census, it has got delayed. It was supposed to be done in 2021. It has got delayed for years. And we have got other surveys which often have some kind of inconsistencies. And this makes things to be very much not so trustworthy. We can't trust. So plenty of data exists on portals like we have this data.gov.in, but a lot of technicalities are there. It's very hard to understand. These platforms mainly serve the senior officials. It doesn't help the grassroots workers or the local leaders. So as a result, the Gram Panchayats or these village councils, which are at the heart of the rural planning, they often rely on their own experience, their assumptions, their guesswork. So there was no simple way for them to make any informed decision, any evidence-based decision, and that's where this Panchayat Advancement Index comes into picture. So what it offers? First thing, a very clear, accessible, and easy to use set of information that shows how each village is actually performing. That will be shown very clearly. Even you talk about the Sarpanch. A Sarpanch can understand this detail very easily. The Sarpanch can use it in their planning part for the improvement. Now this PAI, this index, it was launched by Ministry of Panchayati Raj, and it is designed to measure the development at the Gram Panchayat level. This index specifically is based on 435 different indicators, and each of these indicators, they are aligned with the localization of our SDGs, Sustainable Development Goals we are looking at. So simply we can say this initiative actually it connects global development goals to the local realities. Okay. Now, this index actually covers more than 2.16 lakh 2.16 lakh gram panchayats, more than 2.16 lakhs across India, obviously. So this makes it one of the most detailed tools available for the rural governance in India. So you can mention it as an example in your answers when you talk about rural development. Now, one of the best features of this PAI is that it classifies panchayats into 5 categories. Obviously, there will be some kind of score given. So if a village scores above 90, it's called achiever. Those with the score between 75 to 89.99, they're front runners. Those villages which are scoring 60 to 74.99, they're performers. And if your score is between 40 to 59.99, you fall under the category of aspirants, and obviously those below 40, useless, they're labeled as beginners. So this classification actually helps us identify where we need to put our focus, where we need urgent attention. So these villages below 40, we need urgent attention, right? Now, the significance, if we talk about it, significance of this PAI is very immense. Like it makes it very easier to spot which villages are lagging in areas like health, education, sanitation, drinking water, anything. You'll get this detail. Then it helps the government authorities or the government departments or the panchayat members, even our civil society groups. They can work together in a very focused manner because of this data. Then the funds that are coming, let's say for programs like corporate social responsibility, district mineral fund, this MP lad scheme, MLA lad scheme, all these funds can be directed where they are mostly needed, right? And this index brings transparency, accountability at the grassroots level, and this can be a very much game changer. This can be game changer not just for the central government but for the state governments, the district level governments who want to actually improve the rural development part, rural development planning part. And when we look at the same thing from the constitutional perspective, you look at the 73rd Amendment Act of 1992. That was supposed to be a turning point because it brought this Panchayati Raj institutions. It gave them constitutional recognition and it set this three-tier system: Gram Sabha, Panchayat Samiti, Zilla Parishad. It ensured regular elections, reservation for weaker sections, some decentralization of power. There was an amendment also, Part 9, in the Part 9, which included some articles from 243 article to 243O. All these articles define the structure, roles, responsibilities of this Panchayati Raj institution. And along with that, there was one schedule added, 11th schedule. So some subjects, like 29 subjects that panchayats are supposed to manage, all these were added in this schedule. So these include like agriculture, health, education, rural housing. There was Article 40 also, right? Under the DPSP, we say that it directs states to empower village panchayats to make them, let's say, effective in their governance. So when we look at this kind of initiative, Panchayat Advancement Index, it actually bridges a critical gap that is present in India's rural planning. It's very much helpful and it can bring some smarter, faster and more effective governance to rural India. That will be very much revolutionary, we can say. That's it. Okay. Now, look at this mains practice question. Supreme Court's decision to strike down post facto environmental clearance has far reaching implications for environmental governance in India. Critically examine the constitutional, legal, and ethical dimensions. Simply, you can briefly define what this post facto environmental clearance actually means. You can mention those notifications. Also, you can talk about Supreme Court's decision also. Then the body part, talk about these constitutional dimensions. Then talk about the legal dimension. So this EI notification of 2006, you can mention about it. You can mention about the principles that are present over here, or you can mention these cases brought by the Supreme Court over here. Then you can mention ethical dimension involved over here, right? The generational, future generational aspect, all that you can mention. And in conclusion, you can talk about the judgment. You can praise this judgment, right? Then these questions, I'll tell you the answers directly. So this is mRNA. The first statement was wrong. Second statement is right. Third is wrong. Fourth is right. So 2 and 4 is the answer. Kaladan multimodal transit transport project. So it was between India and Myanmar. So it's very easy. C answer. This question about FATF. So established by G7 to develop policies aimed at combating money laundering. That's fine. India is member since inception. No. It mandates this weapons of mass destruction. True. And this FATF plenary organization meets 12 times a year. No, it doesn't meet 12 times a year. So 1 and 3 is the answer over here, right? Now we have some questions as part of your homework. So please pause the screen and attempt these questions. One question on this Manrega. Second question on this Cybercrime Coordination Center I4C. And the last question related to Panchayat Advancement Index. Pause the screen, attempt the question. We'll get the answer tomorrow in the daily news analysis. Okay, so thank you so much for joining. We'll meet in the next session.